Hello everyone, it's mid-November 2024 and we've had the draft employment rights bill for just over a month now. In that time, employers have been asking us what do they need to do, if anything, to prepare for the upcoming changes to the law, and I'll give you my answer to that right at the end of this video. First, a bit of background. Most of you will know the Labour government promised as part of their election campaign to shake up employment law, the biggest shake-up of employment law in a generation, and they promised to do that within 100 days of power, to introduce new law within 100 days of power. And they met that deadline just on the last possible day. They introduced draft legislation. It's over 150 pages long. There were 28 changes to the law, but there's a lot of detail missing. It feels a lot like an IOU, and a lot of that detail we won't get for some months, for some years in other cases. But in my view, you can summarize the upcoming changes into three categories. The first is called "So what?" The second is "That's more interesting," and the third is the big one. So first of all, the "So what?" category. We've got small changes to things like paternity leave and parental leave. They'll both become day one rights for employees. Looks like there'll be some changes to the flexible working regime, but they should be minor, it seems. Over the summer, the press reported that we'd all get a right to a 4-day working week. That's not going to happen. Statutory sick pay. At the moment, you have to wait 3 days when you're off sick, and you get statutory sick pay from the 4th day onwards. That's going to change, so you'll get statutory sick pay from day one. Most employers we work with pay people from day one when they're off anyway. That's why it's in the "So what" category. But weirdly, it removes the financial disincentive for someone taking a day off sick if their employer enforces the rules rigidly. At the moment, they'll get no pay for that sicky day. But when the law changes, they'll get some pay. Not much though, but some pay. Into the next category, we've got things that are a little bit more interesting. Things like making fire and rehire a lot more difficult for employers, and changes to the rules on collective consultation. At the moment, if you're making 20 or more people redundant at one site, you have to collectively consult. The law is going to change so that you must aggregate the numbers across sites. So if it's 15 at one site, 15 at a site across the country, you'll have to collectively consult. So that will make larger scale redundancies a bit more tricky for employers. And that's on top of the changes in April of this year, which gave greater rights to those who are pregnant, on maternity leave, or have recently returned from maternity leave. So over the next few years, we're going to see redundancies, I think, become a bit more tricky for employers, or there'll certainly be a few more pitfalls for the unwary. Then we've got the big one, and that's the change in the unfair dismissal qualifying period. Well, I say change, there won't be one. It will be a day one right. At the moment, you get 2 years before someone acquires unfair dismissal protection. So in that period, you can assess their suitability, and if they're not right, you can let them go relatively risk-free. The new law is going to be that unfair dismissal protection will apply from day one. There will be an initial period of employment, they're calling it, which will run for 6 or 9 months, during which there'll be a lighter touch process required to dismiss someone. What that looks like in practice, we don't know. There's a lot of speculation going around at the moment, but we don't know. It also looks like the lighter touch process won't apply to redundancies. So another reason why redundancies are going to be a bit more tricky for employers from here on in. But the key takeaway point with all of this is that this change will not come into force until autumn 2026. So we've got loads of time to plan and prepare for it. So for now, what should you be doing? Well, I think my view is not much. I would be worrying more about the additional cost to employers thanks to the budgets, particularly in relation to employers' national insurance contributions. You should also be looking at what you're doing or not doing to prevent sexual harassment in the workplace. From 26th of October, there's a new positive duty on employers to prevent sexual harassment. If you don't do what you can within reason, it could cost you more if there's a claim. Yeah, I think that's about it for now. Watch this space and we'll keep you updated as best we can as we know more. Bye.